Hello, fellow Toolboxers. Welcome to episode 303 of the Immigration Lawyers Toolbox. We have a fan favorite, our monthly interview with Kevin Gregg of the Kurzman Law Firm, talking about federal court updates, VIA updates. It's always a fun, lively discussion with a lot of facts and information, as well as just getting to know us better through it. So I know you're going to enjoy this. These are always episodes that get a lot of views. Before we start, I got some housekeeping I want to let you know of. Our marriage green card course, one of my favorite things to do is to talk about marriage and immigration law, fiance visas, removal of conditions. No, the removal of conditions is a little bit less, but we have a live course we're doing. Again, last one was in, I think, 2020, I think we did it. So we're redoing the live one in a couple of weeks. If you want to register, we have these early bird prices. Email me as soon as possible. In early to mid-October is when live goes, so it's coming up quickly. Email me at info@immigrationlawyerstoolbox.com to get into that. And again, it's going to, these are for people that want to get into immigration law. These are people who are in immigration law, are trying to learn it better. And it could be for firms that have employees they're hiring and they want to train. It just does the training for them, comes with office hours, a lot of good stuff. So keep in touch about that. I also want to thank our wonderful sponsor, Serenade. They've sponsored the magazine and the podcast, a technology company that's been a transformative leader in the immigration space for nearly 30 years. Immigration by Serenade is a modern practice management software for immigration-focused legal professionals to manage their cases, clients, forms, billing, etc. They have bank-grade security, which is a really important part that we need. The software is trusted by tens of thousands of happy attorneys and paralegals who use it to save hours of time for both themselves and their clients. It's worth mentioning one last thing. What really separates immigration from the pack is its comprehensiveness across over 100 features. These include features you might not use today, but can save you time, like an e-filing system. E-immigration is the only platform that offers e-filing for all USCIS forms. Stop paying for multiple software and let e-immigration handle your practice needs. Get more information, schedule a private demo today by visiting Serenade's website, calling 1-800-617-4202, or emailing sales@serenade.com. That's Serenade with a C. Hope that information helps. Get started, get your practice started to update things. Wherever you're listening to this, please leave a 5-star review. It helps the podcast a lot. And as always, this is not intended for individual legal guidance. Please consult with an attorney, but you knew that already. Let's get the show started. Hey, Kevin, good to see you again. Thanks for coming on the show.
Good to see you, John. We're through the summer, although September is kind of summer in Southern California.
Yeah, still today was cool enough where I could go out for a walk and not burn my skin, so that was nice. I think it's gonna get hot again next week.
Yeah, it's good stuff. Good to see
my
you.
associate just came back from Dubai, and he's like, "We just got back in the nick of time. It was like 120. It was getting 120 degrees with 80% humidity." I was like, "Huh? 120? Yeah." I was like, "I'm like, that's impossible. That's out of control." He's like, "It's unbearable there."
That's insane. That's just going to turn into a group of water people. We have to live in the water. Yeah. I don't even know what to say about that.
Yeah, it's wild out there. So it's pretty good out here. San Diego always has a good breeze to it because it's by the ocean. So how's the podcast going, Immigration Review Podcast?
Rocking and rolling. One of the cases I'm going to talk this week about involved I had Ira on the show for just to talk about this very specific case. He demanded that he come on and talk about it. So it's good and continue to get the listens, and I appreciate everybody who does listen and get good feedback. If you have anything bad to say about it, give it to somebody else.
Well, have you been approached by being an expert witness yet? I imagine because you'd be corroborated as an expert at this point.
You honor me there. I don't know. I'm reading the cases for sure. I'm not sure how much that would be valuable for an expert. I think like the experts often happen like in a malpractice case, like what would have been the standard of care for an attorney. I know Ira, John Pratt do those things. I'm not quite sure I'm at that level. They're board certified immigration attorneys. I need to get off my butt and get board certified myself.
Yeah.
I read the cases.
Do other people, because I've done this before, I contact you about like expert, like in a case, like I don't know what's going on with this, what do I need to look and stuff?
That I do get many emails a week. That is true. And
I'm always response schedule conversation.
A lot of them, most of them are like really complicated. I'll be reading it, and most people have already done their research, and they email me their whole thing. I'm like, oh wow, that's It's a lot. Sounds good to me.
Yeah.
Like you're in it way deeper than me, and I'll maybe point people towards a few cases, give my ideas. But I mean, I enjoy it. It makes me a better lawyer as well.
Yeah, the fact patterns. Like I got some woman who contacted me. I'm sure you talk about. It's not a necessarily complex one, but they denied her adjustment because she had a DUI. Well, for one DUI, and I was like, I never thought that was a problem if you have one DUI because you balance it out, and they didn't get in. They didn't give her opportunity to give any equities on the other side. Like it's so adjustment was pending for like 2 years and stuff, and then they did interview. She said I got DUI. Like okay, send us the paperwork, but in the RFE they didn't say give us equities on the other hand positive. So they just denied it straight for DUI not having positive equities. I'm like, is that an appealable thing? Because saying like, well, you didn't give us the opportunity to provide, our side of it or show the positive equities, just ask for the documents, you just specify what you wanted. So I'm like, is it better to appeal that? I mean, this is kind of not the stuff you talk about necessarily in your case, but do you appeal that or just refile it? But one thing that did happen was there was a case 2 months ago that said adjustment of status is discretionary. So on a federal appeal, they won't look into it. Isn't that something that popped up?
A lot going on there.
It was like 8th or 11th circuit. Sorry.
No, I mean, I'll get to that at the end. I mean, I think the 290B motion to reopen to submit the new evidence is the most appropriate, but I don't think it's the best because that doesn't get you employment authorization and that doesn't put you in a lawful status during the pendency of the 290B. So the refile is probably the best. Like even an appeal, you can't get in the new evidence. So that does seem just right off the cuff the best to me if you want to get in that new evidence. As to review of adjustment, I mean, that's Patel, that's the Supreme Court, that's Justice Barrett's dicta, but she's right. It just shows why Patel is wrong. But if you're going to issue Patel, she's almost certainly right. Don't quote me on it.
Oh, Patel was a driver's license one, right? The false claim, mistaken at the DMV or something like that.
Yeah, but it's more about the jurisdiction. And sorry for that call just now. It might happen again. But
I didn't hear it. No, so they get picked up on that.
I mean, it might have. No, I mean, no. It's the jurisdiction stripping provisions. If you're going to say that you don't have that, that the jurisdiction stripping provisions for the specifically delineated forms of relief. If the federal court doesn't have jurisdiction for that, which is what Patel says, an adjustment of status is one of the 5 or 6, whatever you want to count it, designated forms of relief. If you want to say that, then you've got a big problem because, the other jurisdiction, and I'm doing this off the cuff, but the other jurisdiction clauses funnel everything into the petition for review. But now you're saying that that federal courts can't review these issues. And so that does undermine an APA challenge. It's dicta in Patel how all these jurisdiction stripping provisions are meshing up. But most courts now have said exactly that. Like the federal courts don't have jurisdiction to hear anymore an adjustment of status challenge in district court. There is one decision that I'm aware of in the Western District of Washington, I want to say, that has held otherwise, but that judge is very much in the minority, unfortunately.
Yeah,
it's a complicated issue.
Yeah, just going to fact 60. You feel bad first. I mean, UI is terrible, but at the same time, it's just like you got to adjust. I mean, what are you going to do? So, it's always a shock when they take the discretion route because it's usually I rarely see that happen for the deny based on discretion. Plus, these are good facts, and I can't talk more about it. But if no more, it's kind of like kind of ridiculous, but. You never know. We never know when you get a case going. I had some guy email me. He was like, I want to know exactly how long it's going to take. I'm like, you and me both, brother. No, I have no idea how long it's going to take. Nobody does. Like they always, if you want some sort of security and this kind of stuff, that's just not possible. We do our best to try to cover ourselves, but it's just, but I thought I'd share that people too, to watch out. If you're going to send a DUI in, have bona fides of equities and stuff like that to back it up.
Oh yeah.
Yeah, we always talk about church membership and whatever they do. Have you helped somebody do this? We got to put it all in there because we don't know which way they're going to go with it.
Paint the whole picture of the person.
Yeah. Well, good stuff. So what do we got this month on cases?
Well, on that, it's a good segue. I always try to find the good segues. I've got motion to reopen cases out of the Ninth Circuit this week. The first is Fonseca-Fonseca v. Garland. And it's a really important decision in the motion to reopen world. Essentially, Mr. Fonseca-Fonseca is put into removal proceedings. He's got a deficient notice to appear. He probably became eligible for non-LPR cancellation of removal after the Pereira decision, because the notice to appear probably cut off his 10 years. But then Pereira says that a deficient notice to appear does not cut off the 10 years. And then Chavez says that a notice of hearing can't save that. So the stop time rule never stopped. Mr. Fonseca, all these years later, totally has his 10 years. It seems like that's what happened. It wasn't so much about that in this case. I'm reading the tea leaves a bit. But what the board said is like, okay, fine, and you've produced this new hardship evidence showing that your children will suffer exceptional, extremely unusual hardship. But we don't think that it's that you've established a showing such that we should reopen your case. Even though you're now eligible for it, we're looking at it. We don't think that you've met your motion to reopen burden. But the motion to reopen burden is a prima facie showing. That's the burden. Like, but what does that mean? That begs the question. And the two BIA decisions that are always competing, it's matter of Coelho and matter of Log. Matter of Coelho comes out a year or two before matter of Log. Matter of Coelho is like the always cited to decision that says like, motions to reopen are disfavored. You really gotta, it's a high burden. It seems like what Coelho was saying. But in this decision, Fonseca, the Ninth Circuit is saying no. All of that from Coelho is dicta. Coelho was really about that the non-citizen didn't warrant relief as a matter of discretion, by the way, to tie that all back. That wasn't about what is the prima facie showing. Matter of Log is that. Matter of Log is what applies to the Ninth Circuit for motions to reopen. For everybody listening, that is what you should take away. Matter of Coelho, irrelevant, almost. Matter of Log is relevant. Matter of Coelho is relevant because you still got to include the application for the relief you want to apply for when you get your proceedings reopened. Gonna get to that in a second, by the way, in my next case. But matter of Log is the standard on the prima facie showing. And the standard is not that the new evidence would likely change the agency's determination. That's not the standard. That's what Coelho would have you believe. That like it would likely change the determination if you reopened. A prima facie showing, and I want to get the language exactly, is that only a threshold showing of eligibility, a reasonable likelihood that the petitioner would prevail. It's a much lower standard, it seems, than a standard requiring that it would likely change the decision. So it's a big deal. And it's a bigger deal because in matter of Chen, published by the BIA recently, when the BIA had to admit that it needs to follow suit and recognize that these deficient NTAs can now make people eligible for non-LPR cancellation, the BIA, as I read it, essentially said, okay, you have grounds for reopening if you can show that an NTA was deficient and you would have been eligible for non-LPR cancellation but for it. But we're going to apply this really high standard about whether or not you're eligible for it. And this is Fonseca doesn't talk about matter of Chen, but I don't see how those two decisions are reconcilable. I mean, Fonseca is your best friend in the Ninth Circuit if you're now trying to reopen because of a deficient NTA or really any reason to apply for new relief. It is a low bar. Prima facie eligibility is a low bar. And that's what people should take away.
Yeah, interesting. Good stuff.
Matter of Log wins. It's like a 30-year-old fight. I don't know why it's taken this long, but it happens.
Welcome to immigration. Yeah. slow moving. And then when it happens, it's just like the dam breaks sometimes.
Right. And so that's the big motion to reopen case. And this last month, these are the August cases, of course, for that kind of motion to reopen. But that's like all other kinds of relief, non-LPR cancellation, anything else that you want to apply for. By the way, what is prima facie showing for adjustment of status? Essentially that you have an approved visa petition and that you're not statutorily barred because of a conviction or something. That would be my argument. Yeah. Maybe a little bit on discretion, don't get me wrong, but the prima facie showing is not like a whole case. At least that's what Fonseca-Fonseca would say. But the next is Reyes-Corado v. Garland, published by the Ninth as well. And this is a change country condition motion to reopen. So the other type, the kind where you can apply for asylum. And, love this case because it's a big win from my literal neighbors, Ginger Jacobs and David Schlesinger, and their law firm. And, I know they're great attorneys, and it's a hard fought win. And I spoke with Ginger and David, and they've represented Mr. Reyes-Corado forever. So like those are always the best kind of wins. But essentially, Mr. Reyes-Corado had this family dispute in Guatemala, and without getting into it, it involves the Guatemalan Civil War, his father and his uncle on opposite sides of that, and like killing each other, cousins killing each other, threatening each other. It's terrible stuff.
The real Civil War, yeah, that's real.
Yeah,
Civil
right.
War.
And interpersonal Civil War,
Yeah.
but that was his claim in immigration court years ago, and it was denied. But he said things got worse, and so he filed a motion to reopen. Things got worse on that claim. Like the cousins still want to get him. They've been killing the family livestock. They've been threatening his grandma. Those kind of things.
There's that old case from the South. I think Mark Twain wrote about too. These two families that were just the two last names that they're famous. The Things and the Things. Like that.
Hatfield and the McCoys.
Yeah. It's the Guatemalan version of that.
I guess, but I mean, these are actual family members. I mean, they're two separate families, but they're they're cousins. But that's probably the same. Probably the case with Mark Twain too. Everybody was a cousin back then. But I mean, there's great quotes in this one. For example, starting off with saying that change country condition motions to reopen serve as a quote important safety valve in the asylum process. And that's a big deal, especially when you got decisions like Matter of Coelho saying they're disfavored. Well, actually, no, they're an important safety valve. At least when you've got the claim, not when you're abusing it, of course. Before getting to the substance, this is also the Ninth Circuit reaffirming what it said a couple of months ago, but actually being much more clear, saying that when you're filing, and don't quote me on it, read the case because this is a big deal. And to be honest with you, I'd probably still include it. But they're saying when you're applying, when you've already applied for asylum and now you're applying for asylum based on changed country conditions with essentially the same claim, but updated conditions, you don't have to include a new I-589 application with your asylum application because it's already in the record. For all other forms of relief, for a motion to reopen, for all other motions to reopen where a form of relief is the basis, you got to include that application. Ninth Circuit says that doesn't make sense with the change country condition motion to reopen for asylum when you've already applied for asylum. So, maybe still include it because why have the issue? But there's reasons not to, and I haven't included it before. And the case law in the Ninth Circuit, and I believe the Second, but do your research, indicates that you don't have to include an I-589 or even your old I-589 with your motion to reopen. So there's that procedural thing, because that's a great way that the BIA will always ding a motion to reopen. Can't do that ding in the Ninth anymore. But, here then on the substance, the Ninth is saying, materially change country conditions, fine. But it doesn't require a, quote, dramatic change, end quote. Especially when, again, quote, conditions were already severe, end quote. All it requires is that the new circumstances, and this is their quote, I'm just paraphrasing a bit, take the fear across the threshold from, not well-founded to founded. And you can be really close, right? I mean, whatever, let's call it percentage. They say asylum is a 10% chance of persecution to the extent that you can equate such things. I mean, maybe you were at 9% because there was really bad harm, but the immigration judge just didn't see it was there. Well, then a decision like Reyes-Corado would indicate that you don't need some crazy change to get from 9 to 10%. Maybe it's less when it's already severe. And by the way, an interfamily dispute can cut it. I mean, all that was happening really in Reyes-Corado was the same stuff that was happening. It just kept happening and happening and happening. It got a little worse, but that had already been pretty bad. And I said that's sufficient. So Reyes-Corado, monster case for change country condition motions to reopen in the Ninth Circuit, published the same week. I want to say it was it was a couple days after Fonseca-Fonseca on all other motions to reopen. So big week there in the Ninth, big month in August for motions to reopen.
1-2 punch. There you go.
1-2 punch. I mean, you got to think it's intentional.
Yeah, probably.
Yeah, I imagine that when it comes to courts, like a lot of things are, it's almost like a wrestling match planned out ahead of time. How are we going to put it out? And nothing goes to chance because there's too many brains thinking about this stuff and some coordination happens.
I'd love to know the politicking that goes on behind the bench in the appellate courts and the Supreme Court about what they publish, how they publish it, when they say it. Because I mean, it's politicking. They say, that Justice Sandra Day O'Connor was pretty successful at that stuff, as was Chief Justice Earl Warren, because they were both politicians before they came on the bench and, building consensus. We like to think that law isn't like that, but like, of course it is. Of course, Justice Kagan is pulling her punches sometimes and even signing on to a majority decision because she's, maybe she's gotten some concession from Justices Roberts and Kavanaugh for something else. I mean, there's no way that's not happening. There's no way.
I think it was in the movie. I saw a movie or Warren, I think Board of Education stuff. He went, it was negotiating all of them to do it, all that kind of stuff. So it's, if it wasn't boring for regular people, it would make a great reality show or some sort of like a TV show, the judges and show.
You can make it interesting. Add in some sex appeal to the bench, I suppose. Yeah. They have an affair, but I don't even think you have to make up the affairs either. I mean, you could probably, my point is you could probably do.
It's there. Yeah. The contents will write itself.
I don't want to get too deep into it, but the last one, it's not a good one, is the Malik v. DHS decision out of the fifth that Ira came on my show to talk about because he just thought it was just horrible. Mr. Malik is an immigration attorney in Texas. I've never met him, but he's been around for a while. I mean, he's a dude. And, the decision's a bit unclear. To me, the Fifth Circuit seemed to be indicating that his name was similar to an arms dealer. But Mr. Malik actually believes that it was that DHS thought his client's name was similar to an arms dealer. Either way, apparently it wasn't. Like, no arms dealer connections at all, be it Malik or the client. But they took his phone at the border over his objection. They searched all his stuff, all of his emails.
Is a U.S. citizen?
A U.S. citizen. Mr. Malik is an immigration attorney, U.S. citizen. All his stuff. He's getting, and they keep it for like 6 months, and he files an injunction immediately, says, give me back my phone and delete the stuff. And like, they just don't. Like 6 months, I think. And like, clients are emailing. They have access to all his client emails. And this Mr. Malik sues the government for naturalization things for clients and that kind of stuff. I mean, you got
to quickly change your emails so the phone locks out as soon as possible.
I don't know. No indication that anything nefarious is happening by the government. Don't get me wrong. Like they were taking it to use it against these clients, but like that's not really the point. So, like there's attorney-client privilege, and like it just gets blown up. And the Fifth Circuit affirms the denial of an injunction, the grant of summary judgment for the government, or judgment on the pleadings. One of the two, I can't remember. Affirms it all for the government, just says like you have no constitutionally protected interest in your phone at the border, which I don't know.
This is wider than lawyers. If they're going to say this against lawyers, that means no one else has any. I thought U.S. citizens could prevent that, but lawyers who have more standards.
It's the opposite. Being the court watcher I am, like a lot of this is coming from the child porn context where you've got these guys, right? Always guys coming in and like, maybe their name is blips up or something, and the border officers want to search their phone or their computer, and then they inevitably find child pornography, and then they prosecute them, and the courts don't want to exclude that evidence. And like, all right, fine, but like, and then maybe they didn't have probable cause. I mean, Ira's response when I said this is like, we've had this framework with crimes forever, and we still have a probable cause standard. Why is the border special for U.S.? I don't think. I don't. I mean, it's a U.S. citizen, right? But but the phone, and then the decision is recent in the Supreme Court. It escapes me. They've done some of the phone stuff. This isn't new. It's still getting fleshed out, but like it's going the opposite way. It does seem like U.S. citizens have very little protections at the border.
You know how they calculate the border is within 70 miles. So it's like every major, like San Diego, the whole thing is the border. So like
100 miles.
100 miles.
I'm not sure. I'm not sure if that rule applies. I really don't know if that 100 miles from the border things applies to U.S. citizens. I have a feeling.
That means there's no Fourth or Fifth Amendment, whichever one it is.
I think I have all of my constitutional rights, even though I live in San Diego. I'm pretty sure about that. They can't use that border justification, but I don't know. But like more
when they want to, they'll figure it a way.
I think the border, the U.S. citizens, Yeah, your phone is fair game. And I mean, even if it's, again, everyone admitted it was a case of mistaken identity, and you lose your phone and everything in it for 6 months, including all of your client confidences, it's a scary case. That's where we are. And that's why Ira was so heated up and wanted to talk about it on that week's episode a few weeks ago.
Well, I'm not going to talk too much about this one because I'm sure it's going to rile a lot of people, but I haven't read all the things going against Trump, but it seems like they're going against his attorneys for giving advice or something like that as part of like the RICO stuff. I haven't looked too much. I could be wrong. And so it's like, we got to be really, lawyers got to make sure lawyers get away with the stuff. Yeah.
You're going to upset me. I mean, like, as somebody who deals with clients all the time with criminal records or criminal allegations, there's a difference between advising somebody who has committed crimes or is accused of committing crimes and doing it within the bounds of the law and literally becoming part of a conspiracy yourself. Like, I don't. Yeah,
I haven't read the charges, but it's just it has to be really high standard when it comes to going for lawyers' communications. I don't know any of the details. I haven't followed it all.
You've got look, innocent until proven guilty. But when you've got John Eastman out there in emails, which apparently they do, saying this argument has no water, this argument is frivolous, essentially what I believe the emails say. And then Trump is like, I know I lost, but let's do it anyway because they want to play politics. That's not legal advice. That's political advice. And that's playing politics to me with elections. It's not legal advice. That's political advice. And Nixon shows us you can violate the law by playing politics. I mean, since the founding, people have been violating the law, playing politics, and they get prosecuted. So the fact that they have a JD in front of their name, at the end of their name, to me shouldn't matter when you bleed from legal advice in good faith to a criminal conspiracy. We'll see what happens.
No, I haven't. All I heard was like they're going for lawyers, and that I don't know anything about it. I'm still over Trump and hearing anything about it. So I'm just like don't zone out when it comes up. Other than like, oh, they're going for lawyers. That's kind of, hopefully it's not some sort of bad thing out of it.
If you got Trump, what he was trying to do with the documents thing, having lawyers sign affidavits in response to subpoenas saying, we've given up all the documents. There are no more documents for you. If that lawyer knows that they're signing a false affidavit, I mean, it doesn't matter that they're a lawyer.
Okay. Yeah. Okay. I thought it was something different.
I want to say that lawyer in particular has pled out or became state's evidence in the documents case. I believe she was a young attorney and might have been pressured into it. Not an expert on these things. Stay in my immigration lane, but
let's do that.
We're not protected just because we went to law school. If we start committing crimes or becoming part of a conspiracy.
I hear you. So thanks so much for coming on the show. How does this month? I know you're going on a short trip coming up soon, but after that, what is the rest of September look like for you?
No, there's fall conferences. My wife has been awarded an award by the Federal Bar Association National. So we're going to go to Memphis this month and get that award and hang out with non-immigration attorneys. We'll see what happens. See if they cast me off to the side as the weirdo.
No, I doubt that'll happen. But so go to Memphis, and you guys are on the plane all the time, aren't you? Like
a lot of planes. The decision we made when we moved to California.
Yeah, you're in this one pocket of the country where you got to get on a plane wherever you want. Even going to Vegas for you is much longer. You probably fly is easier than drive.
I'm happy that they're expanding Terminal 1. It'll make my life much easier.
For sure. Well, thanks for coming on the show again. Good to see you. I'll catch you next month. And everyone catch Immigration Review wherever podcasts are found. I saw on iTunes, I get a bunch of episodes charting in the immigration space. And I'm like, damn, you like in a short amount of time, you like are packing so many episodes consistently.
Thanks, John. Every week. That's the deal I've made with the devil.
That's hard. Consistency is very few people could do things consistently. So God bless you and for keeping it up, man. Special.
175 episodes and counting. Thanks, John.
You got it, bro. Good seeing you. Talk soon.
Have you ever felt that the road to establishing a successful immigration law firm is riddled with unexpected obstacles and setbacks? I've been there, and I'm here to tell you, you are not alone. Picture this. My wife, then girlfriend, and I had just landed for a vacation, only to be greeted by a voicemail that changed everything. In an instant, once the plane landed, she lost her job. The very one job that was supposed to support us while I launched my own solo immigration law firm. Suddenly, our financial cushion vanished, and I was thrust into the high-stakes world of entrepreneurship with no safety net. Despite a slow start and a discouraging lack of leads and referrals, I remained determined to build a law firm that provided a 5-star client experience. After countless hours spent researching, watching, and implementing marketing strategies with mixed results, I eventually began to see my firm's revenues not only surpass my previous revenue and salary as an associate, but double it. Today, I run a successful law firm with a team of associates and support staff, and I'm the proud founder of the Immigration Lawyers Toolbox magazine, podcasts, courses, workshops, and more. But my journey wasn't easy. I made many mistakes, wasted time and money, and wished I had a mentor to guide me through the challenges. Although I was fortunate enough to find a few peers who offered support, I couldn't shake the feeling that there had to be a better way. That's why I decided to be the change I'd wish I'd seen. This month, I'm thrilled to announce the launch of the Immigration Lawyers Toolbox private mentorship and peer group. This exclusive group is designed to bring solo and small firm practitioners in a monthly, private, and intimate setting to openly discuss business strategies, share successes, even exchange invaluable tactics that they wouldn't share anywhere else. By joining this premium group, you'll not only benefit from my hard-earned expertise, but also forging long-lasting relationships with like-minded professionals who are committed to elevating their practices. Space is limited for this game-changing opportunity. If you're ready to make a real, lasting impact on your business, simply email me at info@immigrationlawyerstoolbox.com. Again, that's info@immigrationlawyerstoolbox.com. And I'll send you all the information you need to get started. Don't miss this chance to transform your immigration law firm and reach new heights of success.